Hello everyone, my name is Shaleen and welcome to Enterclimate. In this video, we will understand the labor laws of India and its compliances for businesses. So, as we know, labor is a concurrent subject. Both the center and the state makes rules on this subject. India's existing labor compliance laws broadly categorizes industries into manufacturing units or factories and commercial establishments. The safety, health and working conditions of the workers are being regulated by the Factories Act of 1948, while the state-specific Shops and Establishment Acts generally regulate the conditions and employment of non-manufacturing units. In India, the labor compliance laws can be broadly classified based on the number of workers and the type of workplace they regulate. For instance, the rules governing the working hours, condition of the service, health, safety, equality, minimum wages, social security benefits, termination, reduction and prevention of sexual harassment of women at workplace have existed. Still, the numerous statutes regulating labor compliances proved to be rigorous for corporations and businesses to keep track of. Indian labor laws can be broadly classified into the following heads based on the areas they regulate. They are conditions of services like working hours, health and safety, minimum wages, equality, social and security benefits, retrenchment and termination, prevention of sexual harassment of females at the workplace. Now let's look into the categorization of labor compliance laws in India. Let's analyze the existing labor compliances laws and the proposed ones. Presently, the labor compliance laws are categorized into two groups: the collective labor laws that relate to the tripartite relationship between employer, employee and the union. The other being the individual labor laws that concerns the employee's rights at the work and throughout the work contract. Every organization must comply with these labor regulations in both the categories to function without hindrance by the government. Assistance and guidance from industry experts can help you with your business and its compliances with the existing laws. Now let's understand the factors that define the applicability of labor laws in India. The workforce in India can be classified as employees and non-employees. While non-employees generally include interns, contract workers and third-party employees and consultants, an employee can be categorized into workmen and non-workmen. From the perspective of law, the Indian laws thoroughly protect the workers category compared to the non-workmen class. The standard labor laws that need adherence to labor compliance depends on the business type and the functioning period. For example, the Contract Labor Act of 1970 that regulates the employment of contract labor in certain establishments. It also provides for abolition in certain circumstances, like when the organization has employed 20 or more workers as contract labor, or businesses that employ 20 or more than 20 workers in a previous year. The second is the Minimum Wages Act of 1948. It applies to any employer if it has employed more than 1,000 workers in a state. It ensures giving minimum wages to the workers in the organized sector. The rule empowers the state government to take steps to decide minimum wages and to revise salary every 5 years. Finally, the Buildings and Other Construction Workers Act, or the BOCW Act of 1996, that applies to organizations where 10 or more workers are employed directly by the contractor or on a construction site. Let's now look into the registration process of the labor compliances laws. So many labor related acts require registration with the appropriate state authorities subject to fulfillment of certain conditions. For instance, the document needed to be produced by the contractor to the employer for approval of employee contract labor includes, for instance, the document needed to be produced by the contractor to the employer for the approval of employing contract labor includes the copy of report providing the legal status of the firm, the copy of receipt, insurance policy or cover note received, photograph proof showing allotment of PF code number, the copy of challans showing remittance of security deposit, the proof of payment of applicable fee. Now let's come to the newly proposed categorization of labor laws in the country. The Government of India has consolidated the 29 labor legislation of the 44 related labor laws in the country into 4 labor codes. This was done as there was a diversity of labor laws and related labor compliances. To simplify the multiple labor laws and the labor compliances protocols, the Centre has also recommended that the measures must be taken to streamline the filing of returns with the regulatory authorities under the labor laws. the government realized that the labor compliance regime under the existing labor laws were detrimental to the labor rights of millions of workers in the country. These four laws include the Code on Wages 2019. This code subsumes the provisions of four laws: the Payment of Wages Act, the Payment of Bonus Act, the Minimum Wages Act, and the Equal Remuneration Act. This code was notified in August 2019 and applies to all units and all the employees in both organized and unorganized sector. The central government will make salary related decisions for employment and labor compliances such as railways, mines and oil fields under this code. The second code is the Code on Social Security 2020. This code subsumes 9 existing laws. Furthermore, it empowers the center to notify social security schemes like EPF, ESI or EPS to benefit workers in all these sectors. The code will apply to any establishment by the notification of the central government subject to the threshold specified. The code and the SS code contains a unified definition of wage that was earlier interpreted differently. The change in the definition of the term wage will require employers in some instances to revamp the salary structure of the employees. The third code is the Industrial Relations Code of 2020. This code on industrial relations seeks to simplify the labor compliance process and promote ease of business in an establishment. It incorporates 3 provisions: the Trade Unions Act of 1926, the Industrial Employment Act of 1946, and the Industrial Disputes Act of 1947. The code applies to establishment as per the formation of the committees and the unions. The fourth code being the Occupational Safety Working Conditions Code of 2020. This code seeks to regulate workers' health and safety conditions in a facility with 10 or more workers and all mines and dock related businesses. Though the President has given permission to the central government on all these 4 codes, the central government hasn't announced an effective date of their implementation. So that was all for this video. I hope you found it informative. Like and share if you did. You can also contact our labor compliance related experts from the details provided below. We at Enterclimate are the leading environmental consultancy company renowned for our technologically driven solutions for a wide range of environmental licensing and compliance services. Subscribe to our channel for more such startup ideas and business solutions. Thank you.